Hello, everybody. Welcome. Thank you so much for having us. I'm Josh Kershenbaum, and I am delighted to be here with Crystal Williams to share with you some of our insights into the intersection between special education law and family restructuring, such as divorce and separation. We think it's a really fascinating topic. It's not one that gets a lot of attention. And Crystal and I had the pleasure of presenting together on this topic recently in California. And we thought that this would be a wonderful opportunity to talk with one of the very few organizations out there that has a whole committee dedicated to this topic of disabilities and divorce and the intersection between the two. So without further ado, Crystal.
Right. So good morning or afternoon to you all. I'm in California, so it's still very early in the morning here. I'm Crystal Williams. I work as an ADR consultant in the area of special education. I'm also a private mediator. Currently, I'm working as a professor at Claremont Graduate University. I am a member of the Southern California Mediation Association. The way that I got connected to special education. I was a special education teacher for 15 years, but I got my start as a one-to-one aide with two fantastic young boys in the Southern California middle school. So that is me and my background. I'll pass it over to Josh.
Thanks, Crystal. So yeah, I'm Josh Kershenbaum, and I am, as I sit here right now, I am a mediator and disability consultant. I work with actually all types of families and institutions that are involved in conflicts that somehow touch the life of a child with disabilities. And that work takes two forms mostly. Mostly I'm working with families that are in the process of going through restructuring, such as divorce or separation, and they have a child with disabilities. And I work with them as a mediator and sometimes as a consultant. I can sometimes consult with their collaborative divorce teams if they're going through the collaborative process. And I also do mediation between school districts and parents in special education matters. And I consult with school districts and others on effective conflict resolution and conflict avoidance between parents and school districts. And that comes out of my work as an attorney. I founded and ran my own law firm, a special education law firm in Pennsylvania here for 10 years. And really all of my work as an attorney was representing parents in special education matters with public school districts. So before that, I was a public school teacher in Newton, Massachusetts. And so all of my professional life has been working with families of children with disabilities in one way or another. And so I'm continuing that work now, but squarely in the dispute resolution sector. I am on the great privilege of being on the training faculty for the Boston Guthrie Academy. That's Woody Mostyn and Susan Guthrie's online mediation and peacemaking training academy, where I've done a extensive training on this topic of how to best support families who are going through restructuring and they have a child with disabilities. And I'm a member of the Collaborative Law Professionals of Southeast PA, where I participate now specifically as a disability consultant to collaborative teams. And in my former life, I was an adjunct professor at Temple Law School. I went to law school and I taught special education law as an adjunct. Thank you for having us.
All right, so before we get started, now that we've kind of shared our experience with disability, we were just curious about your experience with disability, whether that's professional or personal experience. So if we can just do a really quick whip around and just kind of everyone share what your experience is in the area. So I will start with Ian, because I can see your name first. I can't hear anything though. Oh, there you are.
Hi, Ian. Did you hear Crystal?
Oh, I did not. I'm sorry.
Oh, that's okay. I just wanted you to, we're going to have everybody kind of whip around really quickly and share their experience, whether that's professional or personal, with disabilities.
So for me, both personal and professional. Um, my son has OCD, so we are experiencing that. Work has been a little bit of an issue, although currently working, so very happy with that. And some other things that go along with it, touching things and, that kind of thing. And then I have about 30 clients that have children with special needs. So I've seen it all, from those that are having issues at birthing, from those that just, are diagnosed with autism or Down syndrome, all different levels of stuff. And what I find is that the families recognize the fact that there's going to be a transition one day, and that they may be primary caregivers now, and that at some point in the future, somebody else will most likely be primary caregiver. So what does that look like, and how do we make sure that that gets funded in an appropriate way? Also, I find that I do quite a bit of learning from them as much as they do for me. Um, I have 2 clients going through guardianship right now. And it's interesting that they're both going through the same process and having different experiences, um, mostly because of their situation, right? So these 2 both happen to be divorced. One is more newly divorced than the other, and one is a mom who's looking for custody, and one is a dad who's looking for custody. And it just turns out that in one case, the mom who's looking for custody, the dad has a disability. So now the child's going to be needing to be registered as a disabled adult child for SSDI, which is a different situation than getting SSI. So it runs the gamut, and everybody has a different situation. What I find is, by having a nice group or mix of clients, that I'm able to lean on the other clients to help the other ones out, right? And they're all about it, which I think is super awesome. So with their permission, I will ask the other clients for help and/or conversations between them. And I find that it's not just me helping them, but it's also them helping them. So yeah, that's been my experience with that awesome group of people to work with.
Thank you. Does anybody else want to share their experience with disability?
I'd be happy to share, Crystal.
Great.
I
Let's hear
I have a brother who has a pretty serious autism and related disabilities like apraxia and OCD and so on. He lives 24/7 with 24/7 help in an apartment. And I also have a son with serious mental illness who is unable to work or go to school. So I've seen it from 2 different perspectives. And then professionally, of course, I'm an estate planning attorney with an emphasis in special needs. So I see a lot of families coming to me when they're thinking about their own mortality and something like what Ian said. They're thinking about what's going to happen when they're no longer the primary caregivers, and how their child's needs are going to be paid for, and how that's going to affect their benefits. And so that's why I work in the special needs planning area.
Excellent. Thank you so much. So just in the interest of time, if anybody else wants to share their experience, maybe drop it in the chat box so that everyone can kind of read and see who all is in the room with us. So while you guys are doing that, we're just going to talk about our objectives today. So first, our objective is to make sure that everyone kind of is able to recognize the importance of the use of intentional language. Next, we're going to make sure that we can kind of briefly explain so that you guys are able to understand IDEA, which is our special education law. Appreciate how disability impacts restructuring families, and identify steps of the aid process that we can utilize to support these families.
So we'd like to always start off our presentations with a very brief conversation about language, intentional language. you will hear us and everybody else using many different words, terms around disability. And what we want to acknowledge is that this is complicated, and that the terms disability and special needs and all the other terms that people may use, they're imprecise and they're controversial to some extent. They land differently to different people based on our own experiences with the terms, and sometimes even based on where we live and how old we are and all kinds of things like that. Some people view all terms as just euphemisms, ineffective euphemisms, and really disfavor the use of labels at all. And other people have their own particular terms that they really prefer to use. Exceptionalities, challenges, disabled, differently abled, there are many. And other people are comfortable, some people are comfortable using them, some people are not. And we just want to acknowledge that, because we each have to come to an appreciation of why we are using the terms that we use. Everybody's got to pick something. You have to be able to communicate with each other. And so we think it's very important to be explicit with folks about the terms that we're using and what our motivation is when we're using those terms. And for us, like, you'll hear me use the term people with disabilities or disabled people or people with special needs. You'll hear me use a variety of them. I sort of rotate through those. I want to acknowledge also that sometimes I say people with disabilities, sometimes I say disabled people. I go both ways with the people first and the disability first language, because I'm learning from lots of people in that these different terms and different ways of ordering and phrasing things, it really does land differently for different folks. So I just want to make sure that everybody understands that for Crystal and I, where we're coming from is whatever terms we use, however we phrase them, our intention is at the end of the day to ensure in the work that we're doing is to ensure that parents of children with disabilities who are restructuring their families have access to processes and professionals that are designed and prepared to meet their needs. Because as you guys know very well, it's why you have this committee. Families of children with disabilities are very poorly served by lots of different systems all across society. And the legal system is certainly topping the list of that. And the divorce process in particular, separation and restructuring process, there has been a dearth of professionals who really appreciate this intersection. Your committee is one of very, very few, maybe the only that I'm aware of a professional organization that has taken it upon yourself to recognize this intersection and to try to bring good quality services to these families. That's where we're coming from. So when we use these terms, we're simply using it to bring attention to a population and community that's been invisible and underserved by the legal community and by the divorce community. And our intention is really just that. So please feel free to use the terms that you use. And if you'd like to share your intention when you do so, we welcome that. So we're here to talk today about this intersection between special education law and family restructuring. And you'll see this graphic up there on the screen. This is a graphic that my cousin, who's a graphic designer, made for me, which shows you sort of how I visualize this work that you are all doing and that Crystal and I are doing at this intersection, that you have the challenges of going through divorce, the labyrinth of going through divorce, and you have the challenges in the labyrinth of being a parent of a child with special needs. And when you're going through both at the same time, you have this extra complicated labyrinth. And historically, and even up until today, many professionals have been very afraid or been shying away from standing at that intersection. You all are very bravely standing in that intersection and very proudly doing so. And what we're trying to do is to invite people, more people, to be doing just the same. But this is about intersection. All this work that we're doing is about intersection. The intersection that we're bringing into this mix today is one that you rarely hear people talking about, very rarely. And before we launch into an explanation of what special education law is and how it works, we want to sort of prime you for this. We want to ask you, while we're going through this legal stuff, we want you to be thinking, what does this have to do with what might this have to do with family restructuring? How could any of this be relevant or important? So few people are talking about this. So we ask you to be thinking, and then when we're done, that is when we get through the piece that we're going to do about the legal background, we're going to come back to you and we're going to ask you, what did you hear? What intersections? How is this relevant to divorce? We're going to get your thoughts about that. And then we'll share what we see as being the key intersections between the two, and we'll go from there. Okay, so that's your job. Your job is to be thinking, as we're talking about the law, what in the world could this have to do with divorce and separation? Okay, great. Okay, so diving right in. Now, Crystal, I can't see the notes. So
It's okay, I can see them. I can see them.
Okay, so when it's your turn, jump right in.
Okay, so when we're talking about special education law and looking at IDEA, we have to consider 3 things: who's eligible, what is provided, and access that. So Josh, if you want to go to the next slide and then break this down, and then I'll take the next couple.
Definitely. So when we're talking about special education law in big picture terms, there are federal laws that apply all over the country. And primarily there are 2. There's what's called the Individuals with Disabilities Education Act, or the IDEA, which is the one we're going to be talking about today. That's the most important, the biggie. And there's another law called Section 504 of the Rehabilitation Act, which is usually just called 504 or Section 504, which is it's a civil rights act. It's essentially a non-discrimination law that prohibits discriminating against people with disability in public places, including schools. And there's a whole section about providing equal access to education for students who have disabilities. And these laws are different. They overlap somewhat. They're often confused with each other, and people have a hard time knowing whether one applies or the other or both. But the important thing to know is that Section 504 is about providing equal access to students with disabilities. IDEA is a very different type of law. It's a federal law that's not about providing equal access. It's not about equality. It's actually about providing something quite a bit more for students who meet the eligibility requirements. It's a law that was meant to address the fact that historically, students with disabilities were categorically excluded from education altogether, or public schools were allowed to decide not to educate students with certain types of disabilities. And this law was meant to sort of rectify that by saying that, you know what, if you meet the eligibility requirements for this law, you're going to be entitled to an individualized education, something that is not something that other students are entitled to. When you don't qualify under this law, when you don't have a disability, you get what you get. You get whatever education the states provide, and that's it. So it matters a lot whether you are eligible for protection under this. Not every student who has a disability is eligible for protection under this very powerful law. In order to qualify, first of all, it applies to public school students. This is not a law. This law applies really only to public schools. There are some private schools that essentially are functioning as quasi-public private schools who are serving kids who have disabilities and who are implementing IEPs. But I don't want to get into the weeds on this so much. For all practical purposes, this only applies to public schools. It only applies, does not apply to colleges at all. So the law is broken down. It has different sections in it, depending on what age group we're talking about. So there is a section that's devoted to children who are 0 to 3, one that's devoted to sections that kids who are 3 to 5, and then the main section is the K through 12. That's grade 12. That's not, or grade 12 plus, because it's really grade kindergarten through when the child graduates from high school, which may not be 12th grade. It could be after. And then the other thing that's very important to know is that this eligibility for this law and protection for this law does not depend at all on the income of the family. This is not like Medicaid or Social Security. This applies regardless of the child's or the parents' or the family's income or assets. That's completely irrelevant. So, who is eligible? Well, in order to be eligible for protection under this law, two things have to be true. The first is that the child has to meet the definition. The child's disability has to meet the definition of one of 14 different categories of disability that this law sets. There's a list, and the next slide is going to show you what that list is. And each of those has its own definition of what it is, which may or may not be the same as the way a doctor would define it, or the way medical insurance might define it. There's its own set of definitions in this law. But it's not enough to just have that disability. The second thing has to be true. The second thing is that as a result of that disability, the child has to require what's called specially designed instruction because of that disability. Specially designed instruction, or SDI for short. Literally everything in this law has an abbreviation. It's like alphabet soup. SDI are changes to the content, methodology, or delivery of instruction, what's called special education. In other words, they need changes to the way things are taught as a result of that disability. So if you meet those two requirements, you have one of the 14 disabilities, and as a result of that, you need changes to the way things are taught in school, you qualify or should qualify for protection.
So these are the eligibility categories under IDEA. So like Josh mentioned, there has to be a diagnosis or a suspected disability, and the way that they kind of that alone doesn't determine if you receive like an IEP or not, right? But there has to be an evaluation and assessment to determine what the student's needs are and if they have those needs in the areas of that require a specially designed instruction, right? So some of these categories of people, you may experience this and not, you may have experienced them in the past and not necessarily recognize that what you're seeing is a disability. So some students who have other health impairments, particularly attention deficit hyperactivity disorder or emotional disturbance, which is now called emotional disability. Sometimes when you see people who are presenting with these disabilities, it's not what you might anticipate when you think about disabilities. So mental illnesses, anxiety, et cetera, also would fall under these two categories. You may encounter people with these disabilities in your work, but may not be able to identify them right away as having special education unless you work in the field. So, just another reminder, it's not enough to just fit in the category, but you also have to have the need for specially designed instruction in order to receive supports and services. So what does that, what does it provide? So it provides a lot, right? Free and appropriate public education, an individualized education program, which comes with a team, educational placements in the least restrictive environment, that could include private day or even residential placements, related services, evaluations, reevaluations, independent evaluations, measurable annual goals, progress monitoring, transition planning, positive behavior support plans, an extended school year option, and dispute resolution. So there is a lot that is provided under IDEA. Josh, do you want to go to the next slide?
Yeah, I was just wanted to touch on this slide a little bit.
Sure.
It's worth pausing for a second to sort of contemplate that. When a kid shows up to public school in the United States, first of all, it's important to ponder this. There's no constitutional right to an education in the United States. A lot of people find that sort of shocking. But the truth is the Constitution doesn't say anything about right to an education. The only right to an education that students get is whatever their state happens to provide in terms of public education. And states have pretty much tremendous latitude in terms of what they are going to provide and what they're not going to provide to their students. And as long as they're not providing it in a discriminatory way, they can pretty much structure public education any way they want. And for the most part, unless you qualify for protection under some other law, you get what you get. And there's very little recourse if that education is not meeting the needs of your child. When your child qualifies, where a child qualifies for protection under this law, when they meet one of those eligibility, when they meet those two eligibility requirements, just contemplate for a second what they get. A free appropriate public education means at no cost to the parents, an individualized education that's designed to meet their specific educational needs, totally at public expense. An IEP is a contract between the family and the school district that's going to outline what services they're going to provide, legally enforceable contract. An education in a least restrictive environment means potentially placements paid for by the public school district in a sometimes even an out of state or out of district or non-public placement for the child. Or it could mean having a one-on-one aid or supports pushed into the classroom. Related services are things like speech therapy, occupational therapy, physical therapy, transportation, aids, okay? That's all part of the bundle of rights that you get when you're eligible for protection under this law. Evaluations and reevaluations, including the right to an independent evaluation by outside psychologists or therapists or other credentialed individuals who can help identify what the student's needs actually are, all at public expense. To say nothing of the other things like measurable goals and progress monitoring. An extended school year means extend school year beyond the normal school year. That can be over the summer as well. It's not summer school, but it's continued servicing of the IEP over the summer and vacation. So contemplate that is a significant, powerful set of rights that folks who are eligible for this law are entitled to. When you're thinking about what are those intersections with divorce, a little hint, think about this slide.
All right, so like Josh just explained, the actual IEP is an individualized education plan. And I think that that's one of the things that often gets kind of overlooked is the fact that it has to be individualized, right? Specifically tailored to what it is that the individual student that you guys are looking at, that they might need to be successful. So the IEP itself is that legal document that details how the district will provide FAPE in the least restrictive environment and what supports will be provided to assist in the achievement of IEP goals. Go to the next slide. Yeah, so the way that you access, there are a couple of ways. First is child find. So the school district is responsible for initiating the evaluation process when they know or should know that a student might be eligible, right? But in the event that the school district thought that maybe their child might have a special need, then the parent may request an evaluation for eligibility. We always recommend that that's done in writing, but the parents can request an evaluation. Districts must comply with timelines for evaluations. In different places, that timeline is different days, like here in school days. And parents may challenge eligibility decisions, whether that's because they don't believe that the child should have an IEP or whether they think that there needs to be a different eligibility, but the parent does have the right to challenge that decision. So, I mean, these laws are very, very complex, and, you know, by no means is, you know, your average person who's working in the areas of divorce or any other areas that they're just able to, you know, kind of jump into this type of work without any specialized knowledge. So it's very important that you are working with somebody who is understanding of the complexities of these laws, IDEA and divorce law. Go ahead, Josh, if you have anything else that you want to add.
Yeah, just a couple of things to tack on to that. So child find, this notion again is worth contemplating for a minute. You know, we talk about the child needing to be eligible for protection under this. But so you may encounter people who have IEPs and you may encounter people who don't. It's important for you guys to understand that first and foremost, it's the responsibility of the public school district to be identifying the kids who are eligible for protections under this. And that doesn't mean that the school districts have to be certain that the child is eligible before they even evaluate. Even if they suspect that the child may be eligible, they have an obligation, the school district has an obligation to initiate the process of evaluating the child at no cost to the parents to determine eligibility. So the notion that a child has not been identified, an unidentified child, the thing that you need to keep in your mind is primarily that's the responsibility of the school district, but the parents have the right, to request it if they have the concern. And the reason I bring this up now is because many parents, and you guys probably know this already based on your own experience, many parents feel a tremendous sense of responsibility, but also guilt if their child is not getting the services that they need. And it's important to remember that while parents may feel primarily responsible for their children, the law places the burden entirely on the school district to initiate that evaluation process and to make an accurate determination of eligibility. That's really their job. And the failure to do that is a serious problem legally. If the school district fails to evaluate a child or fails to identify a child as eligible, that's a serious problem that requires intervention. The only other thing to mention is something that Kristen already said, but just to make sure it didn't get lost, is that when parents request evaluations, they really need to do it in writing, because the clock doesn't start ticking on the district's timeline to respond and evaluate to that request until they receive it in writing. So it's important that we not only let parents know to request evaluations when they need to, but to do it. Okay, so we have given you a shotgun tour through the key framework and landscape of special education law. And as promised, I'm going to ask you, what in the world could any of this have to do with divorce and family restructuring? So we're going to turn it over to you guys. What intersections do you see? How could this be relevant to people who are going through divorce, who have kids with disabilities? What do you think?
I would say knowledge is power, and knowing that there is an extra component when these two factors intersect is the start. And then knowing what resources can help your client going through it and their special needs child is the key. So I think that is the big broad question to answer your question.
Yeah, so knowledge is definitely power, and it gives you more opportunities to help people. Let me reframe the question a little bit. How could knowing all of this help your clients when they're going through divorce? Why would it matter whether you knew this or not? How might it matter?
If your client is the more organized and the more involved in the child's education, this would be very important information for the court to know about what's required to really parent that child for custody decisions.
So appreciating this is a source of information about what the child needs could inform the decisions that are being made as part of the divorce process. What else?
I was thinking with when you have families going through divorce, which parent is talking to the schools, and so having that intersection of divorce and special needs and who to talk to and who's going to be the main person, the contact for the school district.
So making sure that part of the conversation is who is involved in the child's special education, who's going to the IEP meeting, who needs to receive it, is to know that that's a decision, a conversation that's going to need to happen during the divorce process, and that something is put in the parenting agreement, right?
Right.
Great. What else?
If I can add something, I also think that mistakes can be made, and they're very costly, and sometimes they are not reversible. So the more, to Susan's point, the more knowledge you have, the more power you have also. As a financial planner, I see families who are on the verge of making mistakes by not getting the help or losing the help because of different, financial reasons. So yeah, knowledge is power, definitely.
So Isabel, can I follow up with a question for you about that? You mentioned that mistakes can get made and financially costly mistakes can get made. Did anything come to mind when you were listening to this that suggested to you a mistake that you might be able to help people avoid by knowing this information?
Well, I think just the access to IEP, things like that, the access to the benefits the school offers. I also have a client who has a severely autistic daughter, and she's getting all kinds of benefits now that she wasn't even aware she had access to through the schools, through different programs also. So that's what makes me think of that. Also in my practice, I see a lot of how do you fund the trust, the special need trust and things like this.
Yeah, and so you're finding that the parents are benefiting tremendously and the child's benefiting tremendously from the services themselves.
Yeah.
And you mentioned special needs trust. It's worth just noting here that special education services and benefits are not, they're not the types of public benefits that need to be protected by a special needs trust because they don't have anything to do with the assets and resources of the child or the parents. So unlike Medicaid and Social Security, there's no risk of a child losing eligibility for special education services as long as the child's enrolled in the public school. Even if the child inherited $10 million, it wouldn't change anything in terms of what they were eligible for in this context, but it would be a huge problem for Medicaid and Social Security.
Some families don't know that though. You
That's
have
right.
to let them know. They don't know, so they don't go for the benefits, but you're correct, yes, definitely.
Right. They may be, the parents may be under the misunderstanding that somehow this would, accepting services from the public school could compromise their eligibility for service.
And you know, Josh, where I find this a lot, there's actually now a box on the IEP when you sign off that asks if you have access to Medi-Cal or Medicaid, and if it's okay for the district to like bill Medicaid for some of the services. And a lot of parents get really hesitant about checking that off because they don't realize that that doesn't mean that because they are eligible for Medicaid that they're going to have to pay some extra fee. It just is a way for the district to get some of the things funded and, you know, not have to pay for it out of the district's own pocket. So when parents see things like that and they don't have a real understanding of what all they're entitled to, then that can kind of give them pause about even check marking that box that says that the school can access funds from Medi-Cal and Medicaid if they are able to.
Ooh, that's a great point, Crystal. That is on IEPs, and that does confuse parents. And I guess a little adjunct point to that, the districts are not allowed to bill the parents' insurance, private insurance. The parents are not, they're not allowed to ask the parents in any way to pay for even any part of any of these services, and that includes their private insurance. The school district's billing Medicaid is different because that's public insurance, but none of that will have any impact on the parent's eligibility or the child's eligibility for Medicaid. Private insurance is off limits completely for this. Okay, so did anybody else have anything to share about how this could be relevant to people going through? Those were great examples that everybody just gave.
Hi, Josh. I would add something. Just
Yes.
kind of on a practical day-to-day parenting plan sense. That's something that I help with a lot. And the way I kind of treat it when I'm dealing with parents who are divorcing, who have kids with special needs, is the same way that you would approach an IEP meeting with a school district, developing a list of accommodations, instead of just doing the regular schedule during the school year, during the summer and holidays. We add in a list of kind of accommodations for home that need to be followed. because especially if there's a disparity between, the parents' level of understanding or involvement in these things, one of the parents may not know all the different things that the child is sensitive to that are really required to help them get through the day. So I want to make sure to add that into the plan for them, because, it depends, obviously, every situation is unique, but a child might have tremendous difficulty with transitions. They might have a special diet. They may be on certain medication. And anyone who's a caregiver for that child, if they're going to be exercising parenting time, is going to need to follow all those things if they want to be entitled to have that parenting time.
Yeah, so that's a great point, Rebecca. So, what you're saying is that a lot of what's done in the IEP development process is mirrored in the parenting plan process. So it's possible that information that has already been gathered by the school team or by the parents could be useful in helping the parents do that, and vice versa. If you're having conversations around this during the parenting plan process, that might actually sort of inspire people to think about whether any of this could be modified in terms of what's going on in school. So it could be a two-way street.
Absolutely. And the documentation is important to share as well, because if you have, say, a clinical report that helped you get those services in the school district and make your child eligible, that same report may be the evidence that you need in the family situation to support what you're saying your child needs at home.
Absolutely. Fantastic. Anybody else? Or are you ready to hear what Crystal and I came up with? All right. Let's hear what Crystal and I came up with. All right. So we've obviously thought about this a lot. And you guys did great. You're going to see some of your ideas reflected in sort of our hit parade here of what we see as the intersections between these two things.
So just some of those, like Josh mentioned, I definitely heard a lot of alluding to all of these things, but special ed law matters in family restructuring because there are important sources of funding for services that are available through IDEA. There's an impact on educational placement, the source of information about a child's needs. There's impact of school on home, and then also the opposite, right? There's an impact of what's happening at home on school. And there's also an impact on the child's eventual independence from parents. So special ed law matters a lot in the area of family restructuring.
Yeah, so this, you guys hit on a number of these. But thinking about it on a really practical level, right? Sometimes parents are arguing about who's going to pay for stuff, right? Sometimes they're trying to figure out who's going to pay for all of these treatments or therapies, and how are we going to handle the logistics of getting them to appointments and things like that. And if you have some basic idea about special education law, you might realize, hey, you guys are arguing over stuff that the school district should be providing for free. And if you're schlepping them around to appointments that they could be getting those services in school, that may open up possibilities that otherwise never would have been discussed. And then we get to deal with mistakes like Isabel talked about, of people, perhaps negotiations breaking down, or people coming up with agreements to have them providing services and that actually they shouldn't be paying for in the first place. Any process that could affect where the child is going to school is very deeply relevant to the divorce process for obvious reasons. If the child is going to potentially be going to one public school that can provide the services, perhaps the other parent's school district is not as well resourced, there could be all kinds of implications that affect the parenting plan, depending on where the child is going to school. And then as Rebecca pointed out, you have a potential treasure trove of information about the child, either already in existence from evaluations, or, as is often the case, you deal with this, you often have a situation where the parents don't agree about what the child's needs are. That's so common, right? I mean, I'm sure you guys talk about this all the time. You have one parent that sees the child's needs one way and another parent that sees it completely differently. Potentially, there's an opportunity to get reevaluations by the public school, or perhaps an independent one, that could provide additional information about this. And the last thing I want to underscore is this last point, impact on the child's eventual independence. The whole purpose of this law is to provide these interventions early in the child's life so that they can have the best chance as possible of being independent later on. And anything that could impact the child's eventual independence as an adult has profound implications on the divorce process. When you're talking about parents who have kids with disabilities getting divorced, it is hugely important to them what their role is going to be in the child's life, not just now, but in the future. And the more dependent the child, eventual adult, is going to be on the parents, the more consequential the decisions are that they're making during the divorce now. It's a different financial planning process if the child's going to be living with one of them, or is going to be able to have a job or not have a job. It's a whole different calculation if the child's going to be able to go to college or not go to college. Getting it right when the child is young and getting the right special education supports in early will have a profound impact on the child's eventual independence. That matters a lot to divorce.
All right, so how do we use our knowledge of these laws to help our clients achieve better outcomes? Well, Josh created an acronym that kind of breaks down the steps that we use, and they are to aid our clients, which means to ask, identify, direct, and expand. So Josh is going to start with the ask process, and then we'll kind of go back and forth to go over the entire, the rest of the process.
Yeah, great. So this is breaking down how do we use this knowledge. In this case, we're going to talk about it in the knowledge of special education law, but actually this process can be applied to many other types of aspects of the divorce. Let's walk through. So the first thing is we have to ask the right questions at the right time to the right person. It's one of our most important jobs, as whether we're mediating, it doesn't matter what type of profession, asking questions is hugely important. And what we're encouraging you to do is you want to ask questions as early as possible, not just to one parent, but to both parents. And if possible, asking questions separately for the parents, not at the same time. Why? Because it's very important to know the areas where they agree and disagree and where they may have questions or missing information. That is very useful to you in terms of structuring this process. You want to make sure you're asking questions about all children, not only about the children that they have identified as having disabilities, because they may not be aware of or thinking about the other child as having a disability, but you may have some insights to suggest that perhaps they would qualify for eligibility under IDEA. And always be sure to include I don't know as an option, so that because it matters to you whether the parents know or don't know this information. We also want to make sure that the questions that we're asking are intentional questions. They're intentionally designed for really two reasons. We want to ask questions that will help us understand the gaps in knowledge, the things that the parents don't know, or that they don't both know, where they're really missing information. And we want to understand what areas do they agree on and what areas do they disagree on. So we design questions with intention to elicit those two things, gaps in knowledge and areas of agreement and disagreement. So we gave you some examples here, the types of things you want your questions to be designed to bring out. We want to know if the child might meet the eligibility requirements for special education. We can't just ask the parent that. We can't say, does your child meet the eligibility requirements for special education? We want to design questions that will get that information out of them. We want to understand how each parent perceives and understands the child's needs. Well, again, oftentimes it's going to be different. We want to get questions that get at their perception and understanding. We've already talked about, we want to get questions that show how aligned they are, where they're not aligned, so that we can anticipate the types of conversations that we need to have with them and to help them gain alignments. And we want to find out, are they paying for things that perhaps Medicaid or the school district should be paying for? So you want to ask the right questions, find out what they're paying for, find out what it's costing them to pay for things related to their child's education. And be sure to include things like speech therapy, physical therapy, and occupational therapy because those are related services that the child could be getting in school. And we want to get a sense of how prepared and concerned the parents are about the child's future, because we want to be able to have conversations about getting alignment on the right special education services so that the child can be as independent as possible.
So it's not enough only to ask basic questions, right? Asking, does your child have an IEP? Sure, it's important, but it's not going to reveal a number of things that you actually need to know. If the child might be eligible for an IEP. So let's say if the parent, you ask them, do they have an IEP, and they say no, that doesn't help you if the child might potentially be eligible for an IEP. If the child is receiving the services and parents understand what the child may be entitled to, how the parents each understand and perceive the child's needs. So it's really important to focus on asking probing questions, like, has your child experienced challenges in school academically or socially? Has anyone ever expressed concern about your child's performance or behavior in school? Has your child ever been suspended or expelled from school? How much have you spent in the last 12 months to meet your child's educational needs? So those types of questions are more designed to find out the type of information that we were just sharing that is really critical to making sure that the children have exactly what they need and they're prepared for their future.
And if you do ask questions like this early on, you are distinguishing yourself from everybody else, because very, very few professionals ask questions as detailed as this. But you guys obviously are all committed to working with families who have kids with disabilities. So think about your questionnaires that you use, think about the early intake interview questions that you ask, and come up with that really comprehensive list of questions that's going to help bring this information out early. So that brings us to the next step. So you bring out all this information, right? That's great. The next step is, it's our job to identify what. This is sort of like issue spot. So there's two aspects to identify.
So we have to look for opportunities for team and for conversations and challenges. So opportunities as far as identifying gaps in knowledge and areas of agreement or disagreement, reframing them as opportunities for learning, understanding, growth, and to better meet their child's needs. So for example, their answers might reveal that they're unsure or disagree about the child's needs. This is an opportunity to obtain an evaluation. Maybe there needs to be mediation or learning about evaluation rights. So being able to identify the gaps helps us to kind of look at their answers more closely and see what's being revealed to us. As far as the team, we can identify the ways that the current team can support the parents in answering open questions and achieving agreements, and where other professionals might be needed. And then we can look at conversations and challenges. We need to identify the conversations the parents will need to have to answer open questions, achieve agreement, and maximize their opportunities to learn, grow, and better meet their child's needs. So for example, what medical, mental health, educational support does the child need from others? And then it also allows us the opportunity to identify facts and circumstances that are creating significant challenges to answering questions and reaching agreements in the case. So for example, looking at limited options in their areas for supportive professionals and services.
Yeah, and so on that last one, you ask the right questions. It gives you as the professional the opportunity to learn early on, to get a heads up early on if there's going to be some really challenging issues in the case. So if you ask the questions in the right way, you might find out, okay, this is a situation where this child is likely going to need significant services, and I can already see that they're living in a very rural part of our state. And so I am anticipating that there could be some real challenges in access to services in this case, and it gives you the opportunity to think that through and to come up with some ideas even before you meet with the parents for the first time. So the more prepared you are ahead of time, the less of a crisis you're going to be in when these really difficult issues pop up, in the middle of your mediation or divorce process. This is really empowering for you as professionals to get this early as possible.
So the D in the AID process stands for direct. So who are we directing our families to? It's our responsibility to connect parents with professionals, services, programs, supports, information, and other resources that they might need to create a team or expand their existing team. So maybe they have some of these people on their team, but maybe they don't have all of them. Maybe they don't need all of them, right? But we want to have a network where we can to mediators, divorce coaches, special education advocates or attorneys, neuropsychologists in the event that there needs to be an evaluation. We can link them to Medicaid and SSI application portals, to estate planning attorneys, et cetera, et cetera. The list of people who could be on the team kind of could go on and on, needs of the family and the child.
Yeah, and as you guys are a living example of, you are guys a living example of how multidisciplinary this work is, how it really does take a team of people with various expertises and experiences to be able to support the families. There's no way any one person can meet all of the needs that this family has. So this is a really powerful opportunity for you to connect them with resources and also to connect yourself with a whole network of people that support people with disabilities. That's a very powerful networking opportunity for you as professionals. The last piece of the AID model, the E, is expanding. And really what this is talking about is helping you as professionals redefine or really define what success means in these cases, right? These can be very challenging, complex situations. And I think sometimes we can focus in on all the things that we can't do. How we can't fix these problems. We can't make a disability, change a disability or make it go away or change it in any way. We can't sometimes make services appear that just don't exist in the area. There's a lot we can't do. But what I really want you to do is to realize that you have an opportunity by asking the right questions, by identifying the conversations that they need to have, and by directing them to resources that they wouldn't have otherwise had. You have an incredible opportunity to expand opportunities and lower risk for these parents. Isabel really nailed it when she said, if you don't have this information, the parents are exposed to all kinds of risks of making mistakes or committing resources that they shouldn't be committing. You have the opportunity to lower those risks by being aware of all of this and by creating opportunities, by helping them have conversations that they wouldn't have even had otherwise, or to have them in the right way, perhaps with the help of a mediator as opposed to going to court over it. By maybe you're the one that actually put the idea in their head that their child can even get access to special education services in school. Maybe you're the one that helps them find that advocate that can go to the IEP meetings with them. That can change their life. That can change the future, the child's future going forward. You are in a position to create an outcome for them that is vastly better than what they would have had otherwise. And that's exactly why we're all doing this work. It goes back to one of the first slides we had, that we want families who have kids with disabilities to have access to the types of professionals that can help them in their situation. And by knowing this information, asking the right questions, identifying the issues and making sure they're having the right conversations and connecting them with resources, you are changing the future for them. You might never know exactly how it would have been different otherwise, but you can be sure that their outcomes are better than they would have been had you not been on that team.
All right, so we're at questions, and I know that Rebecca Stern had a question in the chat box for us. I told her we would come to it when it was that time. So her question reads, do you on accommodations, a student with a 504 plan may be entitled to access as distinguished from an IEP. For example, a student with a long COVID diagnosis impacted her education who receives an IEP may have excessive absences excused. What if the same student only has a 504? Ability recognized. Is there a lower bar here for what can be received? So that's a good question, Rebecca, but Yeah, I mean, a 504 plan is still similar to an IEP in the fact that it's being designed for that specific student in mind. So I don't see it as like a lower threshold of what can be offered as far as accommodations because a child has a 504 plan as opposed to an IEP, if that makes sense. So you know, there are similarities and differences between a 504 and an IEP, but the goal is to provide both students with the opportunity to so for if you have a 504 plan, the goal is to give a child equal access to learning at school. The IEP is focused on special education services and the specific types of services that can be provided, but both of them can come with accommodations. And it's really just about the accommodations that are going to help this student with the 504 have equal access to learning in that school system. So that it doesn't, just because they have a 504 doesn't mean that the types of accommodations that they're going to receive are at some sort of lower bar than what would be available to a student who has an IEP. The accommodations that go into the plan are really determined by the IEP team itself. And I mean, by the 504 team itself. So it's not that somebody would be looking at, oh, well, these are the accommodations that we would give a student who has an IEP, and these are the only ones that we offer to a student with a 504. It doesn't work that way, right? It's really about
supposed
looking
to
at
work that way.
Right, it's not supposed to work that way. You really have to look at what the child's individual needs are and figure out how you can help that student gain access to the curriculum. And that's really the conversation that's supposed to be had around accommodations. There shouldn't be a discussion of, oh, where your child only has a 504 plan, so they aren't eligible for as many accommodations as a student with an IEP. So hopefully that answers your question. If you have a clarifying question or anything else that you wanted to add to that, Rebecca, if you wanted to clarify something,
Yeah,
then.
so this is actually a situation I'm dealing with a client right now. So I thought I would take advantage of having all the special needs brains here because it's a nuance that I hadn't seen before. And I understand, you know, a lot of the fundamental differences between a 504 and an IEP and what follows you and the role of the parents on the team and all of that. But what I wasn't sure about was something like attendance because of a medical issue. I have a client with an IEP for long COVID, and of course, absences were excused, so it didn't impact her transcript. She, you know, being given modifications that measured her level of knowledge, as opposed to you have to do all the busy work, let's say. But with a 504, I didn't know legally when there are state attendance requirements, if they're just as entitled to sort of break the rules because this is an important reason, because this child has a disability and therefore couldn't attend as much as the school's normal policy requires and the state requires. And because parents aren't even, you know, necessarily given as much power on that team, on a 504 team, as they are on an IEP team, do they have the same, I guess, right? Like,
So,
is
Rebecca, can I just ask, I mean, this is a great question that a lot of people are going to be struggling with about whether it matters, whether the kid has a 504 or an IEP. And in this particular case, the question I would have is the school district saying it matters? Or is the school district saying, no, sorry, you can't have this particular accommodation because that's not something that's 504.
Exactly. The school district is.
So then if that's the question, then the conversation has to be then, okay, well then, does the child meet the eligibility requirements for an IEP? And if they're making it an issue, then the conversation has to be about eligibility for an IEP. Then again, two prongs. Does the child fit into one of the categories? Long COVID, depending on how it's manifesting. So you didn't see long COVID on that list, but depending on how it's manifesting and what literally is, what is doing to the kid, it's possible that they might fit into one of those categories. Other health impairment, for example, covers things that have to do with affecting attention and things like that. Look at the definition of other health impairment and see if it fits into what's actually going on. Forget about the label, forget about that it's called long COVID. Does the child have a condition that is affecting them in the way that's defined in OHI? And is it making them require changes to instruction? And if so, then the conversation should be about eligibility for an IEP. So that the question is, does it matter? Well, part of the answer is the school saying it matters? If the school is saying it matters, then we have to take a look and see, you fit the requirements for IDEA.
And then
So-
Rebecca, I wanted to just go back to another point that you made about the parent's role not being as equal in the 504 as opposed to the IEP. That's not true. The parent is an equal participant and contributor to the 504 team in the same way that they are to the IEP team. So the parent shouldn't be being made to feel that they're less important as far as providing input or anything like that. Like, they are a part of the 504 team as well. It's just the people who are required to be a part of the 504 team versus an IP team is different, right? But the parent is listed on both and is a central piece to both teams.
Yeah, the other thing, just to honor, like Crystal's doing, honor the question, you know, on a legal matter, sure, it's true. Like, parents have, you know, are equal participants on the team and all of this. But as a practical matter, in reality, it often does matter whether the kid has an IEP or a 504. In terms of the attention that the kid is going to get in school, what staff or who's going to be on the team, and also in terms of what accountability does the district have, what power do the parents even have to enforce it. It's a totally different dispute resolution process under 504 and IDEA. And frankly, parents have more power and protection under IDEA than they do under 504. It's easier to access dispute resolution under IDEA than it is under 504. And typically school districts feel a little bit more push to comply with IDEA than they do with 504, even though legally, Crystal is absolutely right. They're supposed to be following both. And interestingly, both laws do provide this notion of a free, appropriate public education. There is a FAPE concept under 504, but the courts haven't interpreted it as being exactly the same thing as what you get under IDEA. And so it's made it so that 504s often feel like MIC-IEPs or IEP lights, or that it's really not the same level of protection. And in some practical senses, that's true. So when it's very, very common that, particularly for kids who have, only thing they have is attention deficit hyperactivity disorder, it's very, very common for school districts to give the kid a 504, but not an IEP. And that can be something that presents itself in your cases. It's sometimes valid, but it's a red flag. It's a red flag you should be paying attention to see, okay, they found him eligible for a 504. Why was he not found eligible for an IEP? Because the truth is, reality is, that many, many kids who are found eligible for, it's a different eligibility standard under 504. It's not the same process and definitions under IDEA, but many kids who are found eligible for 504 for ADHD are actually eligible for IEPs if someone's asking the right questions and getting the right evaluations.
That's really
And
helpful. 'Cause I think that's what I was kind of getting at, was legally, because I'm not a special education attorney, what's the right approach? And I was thinking, if they're really pushing back with the 504, while we're having those conversations, they request evaluation for special education services. And even if they don't get the IEP, going through that process puts them in a better position if they do have to file a due process claim.
And you know what I was going to say too, Rebecca, I think a lot of the times what it really has to deal with is how knowledgeable the people who are putting together the 504 plans are about Section 504, right? Because a lot of times most schools are hyper focused on their IEPs and don't have anything set up for students who have 504s. And then the first time somebody comes in with a 504 or requesting a 504, then there's a lot of confusion about what the process even looks like. So things may be getting denied because people just don't know enough about it. But because the law says that there has to be somebody that does 504, they'll put a coordinator a 504 coordinator that just has no idea what any of this process entails, right? So asking more questions about how they're determining what's appropriate and what's not appropriate. And then knowing that there are options for resolving disagreements when you have a 504 plan. You can still request a mediation. You can go through ADR processes. You can request an impartial hearing. You can file a complaint to the Office of Civil Rights, or you could file a lawsuit, right? So there are avenues to resolving disagreements when you have a 504 plan. But I think that where the issue comes in is the school and the district's policies on 504, how well established they are, and what is the team and their processes. So asking for their documentation about the 504 plan process, like what is their procedure, right? Because there should be some sort of outline about making referrals, plan reviews, who's on the team, and that kind of stuff. There should be a meeting, right? But I have worked at several schools that were like, oh my, somebody has a 504, who handles that, right? Oh, you're the special ed teacher, you must be the person. I'm like, oh no, actually a 504 is a general education function. You need a team that doesn't consist of me. I could come in and kind of maybe provide some expertise about the differences, but this is a general education function. And I think that a lot of times that's where the confusion comes in around doesn't have a solid plan about what to do for 504s, and they find themselves in due process, and then they have to create a plan, and they realize they didn't have a plan, and then things are kind of able to be resolved once they can formulate that. But it really is just going to depend on the district's plans are and what processes have been set up within their district to support them in making sure that students who are supposed to have a 504 plan have something that's relevant and helpful for them, right? But as far as like accommodations, it shouldn't be, oh well, you don't get this one just because you have a 504 and not an IEP. Accommodations and even modifications can be granted under 504. It's just really about what does the student need, not to give them some sort of unfair advantage, but just to keep them equal with their other classmates. And if those accommodations will do that, I think that's kind of the argument that needs to be made, is that this accommodation doesn't give her any type of modified curriculum. This is just giving her that much more more access to the curriculum, right? So it's not.
Yeah, Josh, I have to jump in and call a close to the Q&A.